we're talking about inventions made by computers. Whether we call them artificial intelligence or whatever doesn't really matter. This is just a schematic view on what we're talking about. Now, inventions used to be made by humans. That's very clear. So inventions historically, on the bottom line, you see the time axis. On the left-hand side, it's the past. And on the right-hand side, it's the future. So inventions were made by humans, no doubt about that. But this tends to change, not across the board, perhaps, but there are a couple of software products that are quite smart in what they do in a particular field. We're not talking about super robots or general artificial intelligence. No, we're talking about special programs that were programmed for a particular technological niche. And some of these programs are quite good, quite helpful for those working in that field. And some of them perhaps maybe go as far as doing something that, if it were done by a human, we would call an invention. We will dig into that, whether that's really the case or not. But if it is the case, what does that mean for patent law if inventions aren't, well, if there is an invention, it is a single one that hasn't been produced, devised by a human, but by a computer? What is the consequence of that for patent law? Does patent law have to change? Shouldn't we get patents for these sort of innovations, or is patent law fit for it? Let's see. So how did it all start? It started with Professor Ryan Abbott, who you will meet on Friday. So he wrote a couple of papers, gave a couple of presentations on computer-generated inventions, or artificial intelligence generated invention, whatever word you would like to use. And I heard one of his presentations. I met him during the coffee break, and it was very nice. And then he gave a presentation, and he had very far-reaching hypotheses, like we don't need patent law anymore. If the computers make the inventions, making an invention becomes trivial, and so on and so on, the far future. But I thought it was kind of interesting, and because I know that powerful software solutions exist around the world, in quite a few of them actually. So I went back to my office, and once a month I meet with a couple of colleagues, among which Markus Rieck. And I talked about computer-generated inventions and Ryan Abbott and the ideas that are around. And during that discussion was born the idea to further draw the attention of the public on this question, and the legal community, the IP community on this question. It's not sufficient, or not really helpful, to write another book or another article, give another presentation on another conference. What we would need is decisions by important courts that will create public awareness. And that was the idea. And so I called Ryan and said, hey, Ryan, let's make a patent application, because Ryan is a professor and I'm a patent attorney. So, and I'm on the side, I'm editor of the German law on patent law, German magazine on patent law, sorry. And so I have a little bit of a feeling what causes attention in the public arena. And so I called Ryan and said, Ryan, all your papers are fine, but to really create awareness, we need a patent application, and we have to present it to the patent office, and that will likely move on to patent court, and that will create public awareness. But in order to do that, we have to write a patent application on an invention generated by a computer, and it must be the truth, of course. So we need an invention generated by a computer. Ryan, do you know anybody who has a computer that can generate an invention? And he said, yeah, let me make a few phone calls. And he made a few phone calls, and he came up with Stephen L. Thaler, a man who has become world famous in the IP community, at least. by now. So Stephen L. Thaler has a machine called DABUS, or later on he called the machine DABUS, or maybe before, I don't know. And this machine generated an invention, which people used to call the neural flame. It's a flickering light that if you have undergone shipwreck or whatever, you can turn it on and it will draw the attention of people looking. It will draw the attention of these people to your flickering light because it flickers irregularly, and that will automatically draw the attention, attract the attention. If it would flicker regularly, it would attract fewer attention. Now, the problem with this invention is I wasn't totally convinced, because he was talking about fractal and fractal dimension in that train of light pulses. And having a PhD in physics, I just couldn't see the fractal dimension. So I called Ryan and said, hey, Ryan, this is, if we want to go to the public, this is something I would rather like to avoid. Can we have another invention? And that was not so easy for Ryan, because then maybe Stephen is turned off or whatever. But eventually Stephen came up with another invention, the so-called fractal container. And that's fine. That's fine for me too. It's a container. It's a teapot, a mug, if you want. And the wall of this mug has a particular shape, namely a fractal form, which is correct in that case. And if you're anyhow knowledgeable in fractals, this is a Koch snowflake, or maybe the English community would call that a Koch snowflake, but as a German, I would call it Koch. So that's fine. It has particular advantages. Thermal isolation can be grabbed easily and things like that. So that is an invention, and it was created by Davos. At least that's what Stephen told us. So what is Davos? Davos is a system developed by Stephen, patented by Stephen. So he made an invention. The invention is this machine, which is probably a computer implemented invention. It's probably more a piece of software than a piece of hardware. And on the left-hand side, you see a first neural network, which he will disturb. He will heat it artificially, and then he will cool it down again, because that's sort of simulated annealing. And by cooling it down again, it will settle into new technological concepts, new ideas. So it's a machine for idea generation, which he built. We don't actually have to go too much into the details of the technological details of Davos to answer the legal questions. And now the new ideas generated by Davos will then be observed by a camera, which of course is a piece of software too, and presented to a second neural network, which then filters them for novelty and importance and interest. And finally, those who get through will be presented to whoever has new ideas. So, and Davos did create these two inventions. Davos, by the way, means, what does it mean? It means device for autonomous bootstrapping of unified sentience. Don't ask me what that means. So we did file actually two patent applications, both for the neural flame and the fractal container. There were priority filings in Great Britain and the European Patent Office, and they were, subsequent filings were deposited at the WIPO, coming from the US, I think. No, directly at the WIPO. And we named in Europe, in Great Britain, at PCT, and in Germany, which we also did later on. I did that personally. We designated Davos as the inventor. And it was clear that that would create some frowning of eyebrows in patent offices, but not so for WIPO. WIPO took Davos as the inventor in their database, and they published They published the PCT application for, which one is it here? Can't recognize, the title isn't there. Never mind, I think it's the fractal container. They published it with DABUS as the inventor. That would have been the last step it takes to cause widespread awareness in the audience, but the hype had already begun. The European Patent Office had already started a consultation of the member states, what they think about it. WIPO had started a diplomatic conference on the subject, and so on and so on and so on, you name it. Now, but the question is, it's not about attention seeking, it is about how does patent law cope or has to cope with this new phenomenon that some inventions are created by computers. So one differentiation is very important. Oh yeah, sorry. We imagine a person like Stephen Thaler who is building an artificial intelligence. So that typically will be what the European Patent Office calls a computer implemented inventions. This has been discussed at length. We all know what it means. If then this machine generates an invention like a fractal container, this invention is not a computer implemented invention, but it's just a teapot. It is a computer generated inventions. So this differentiation is very important, just not to mix up. If people talk about AI inventions, then it is not clear. Are they talking about an AI system that has been invented by somebody, or are they talking about something that was created by the AI system, which is a computer-generated invention? So I will avoid the term AI inventions. I will talk about computer-generated inventions. Okay, on the left hand we have Stephen Thaler, in the middle we have DABUS, and on the right hand side we have the fractal container. Now, the open questions that are generated by these patent applications, by these patent filings, are as follows. I hope you can see the green first question, I think should work. So question number one, can a computer at all devise an invention? It may seem trivial to some of you, but it was denied in the United States by many, saying no, only humans can devise inventions, can make conception of an invention. A machine can't do that. Following which, if this question is answered to the positive, then the next question arises, is such an invention, a computer-generated invention, excluded from patent protection as such, per se, not patent eligible, because it was generated by a computer? So are patents here only for human-made inventions, for human creations? Is the patent law in place to help human inventors, or does it have some other reason? The third question will then be, if the second question is answered to the positive, yes, you can get a patent, then who is the inventor? Or more precisely worded, who can be designated as inventor in the meaning of the patent law and before Patent Office? And then later on, not in this talk, there will be a fourth question concerning inventive step for computer-generated invention, but this is not part of my talk. I can make a comment on that if there are any questions about it, but it's not part of the first 45 minutes. Now, I will start with the legal part. The first question, as I said, is, can a computer devise an invention? To answer that, we have to ask ourselves, what is an invention? What does devise mean? So what is an invention? A flash of genius or a technical teaching? Very simple, a technical teaching. Now, for Germany, it is a technical teaching. For the US, it used to be a flash of genius, but it isn't anymore. For Europe adopted actually the definition given to an invention by the Federal Court of Justice in Germany in the decision by the Enlarged Board of Appeal, G2 of 07. So an invention is a technical teaching. In the US, the definition is different. But in view of the time, I have a watch sitting here over there. I think I should hurry up, so I will not spend time on the US during my talk. You can ask questions on that if you want in this second part. For Europe, and I will concentrate on Europe, I will not comment too much on Australia or other countries. In Europe, we can say an invention is simply a technical teaching, and actually nothing more. Doesn't have to be new, doesn't have to be patentable or whatever. It's a technical teaching. Any technical teaching is an invention. So, and here is an example of an invention that I purport, and I would say has been generated by a computer. This is the, how do you call that? Hinterradopphängung? So the mounting of the rear wheel of a motorcycle. The mounting is actually missing here, and it is the task of the computer to design the mounting of the rear wheel. What the humans will pose as a problem to the machine, which is actually a commercial program that you can buy from Autodesk. I'm not sure whether Autodesk is the company or the name of the product. I'm not sure, but it's a generative design tool that you can buy and use. So the mounting of the rear wheel can be attached to the green parts. It may not touch the red parts. Now the machine, and it has to carry a certain load, certain stress levels, 500 kilos, I don't know. Huh? So the machine will devise a number of solutions. These solutions can be sorted by least weight or whatever you want, criteria you can program into the machine so that the machine can finally come up with a single solution like this one. And I took these photos from the Autodesk homepage. That is what their system can do. And this is a technical teaching. And actually, it doesn't look like a rear wheel mounting device by a human. It looks like maybe Colani, but not even Colani would look like that. You can see that it was generated by a computer, and it was generated by a computer. And it is a technical teaching, so this computer program generated an invention. And there are other examples. These are antennas from NASA. I'll skip on that because time is running. And of course, there is the fractal container. So I think the first question is answered. Some computers are able to generate an invention, to devise an invention, because this software, at least Autodesk, from Autodesk, generated a technical teaching for a rear wheel mounting. So it did generate a technical teaching, and a technical teaching is an invention. Whether that's new or not is irrelevant when we're asking the question, is it an invention? It probably is new, but it doesn't matter at this point in time. So now we know what an invention is, and we know that a computer kind of can generate something like an invention. The next question, legal question that's on the table is, who is the inventor? So what is the legal definition of inventor? Very nicely worded in Section 7 of the UK Patent Act. In this act, inventor, in relation to an invention, means the actual deviser of the invention. So it's important to note, and this definition is not only true for the for the UK, it's also true for Germany. It's also true for the EPC, European Patent Convention. So the inventor is the person who devised the technical teaching. It is not the person who posed the problem. The problem is not the invention. The solution of the problem with technical means is the invention. So somebody who poses a problem is not an inventor. Somebody who solves the problem is the inventor. The person or thing or AI or whatever that devised the invention, actually, factually devised the technical teaching. That is the inventor. So whoever or whatever devised the technical teaching, that is the inventor by current definition. So did Autodesk invent the rear wheel mounting? Did Davos invent the fractal container? I think the answer is yes. In the US, it might be no, because only humans can make conception. But as I said, I wouldn't want to dig into that. It's kind of strange also to a European thinking. The European Parliament clearly states an intellectual property action plan. In its intellectual property action plan, AI technologies are creating new inventions. And that's what I think too. It is Autodesk that devised the technical teaching. So Autodesk is the inventor by traditional definition. On the side, Autodesk is a computer and not a human, which will open up other questions. But who devised the invention? Autodesk did devise the invention, and Davos devised the invention. So the answer to this question, can AI devise, conceive an invention, is clearly yes, and no is for me not the correct answer. Maybe for someone in the US, not for someone in Europe. Okay. Next question. Should this invention be excluded from patent protection because it was devised by a computer? Some would say yes, perhaps, but the big problem with saying yes is that people will simply lie. So that is actually not a very intelligent option, neither for case law nor for the legislator. Some other people have said we need a special type of property right just for computer-generated inventions. But we will have the same problem. If this special type of property right gives you fewer protection than a patent, then people will simply lie. So this is actually nothing we can really do. And I am very, very happy, really very happy that the European Parliament took a very clear position and said, technical creations generated by AI technology must be protected under the IPR legal framework. And that means the existing IPR legal framework. And the IPR legal framework means patents, trademarks, designs, utility models, copyrights, whatever. Copyright is perhaps a different question, but it certainly means patents and designs. So that is really a very, very important step in this whole discussion, which we triggered, that the European Parliament and the Commission as well, but the Commission wasn't totally clear, but the European Parliament was on this second very, very important question. Can there be patent protection for computer-generated invention? The European Parliament said yes. And the European Parliament is a very important legislator. Now, we took this case to several courts. I think 2 of them I would like to comment a little bit in detail. I mean, I think 20 courts or even more have given judgments, decisions on the question of Davos as inventor. That's the only thing we have asked so far. Davos as inventor. Can Davos be named as inventor? 2 of them, I think, are quite interesting for us and close to us. One is from the Board of Appeal of the European Patent Office. It's J8 out of 20. You may have heard about it or read about it. And the other one is from the Federal Patent Court in Germany, the Bundespatentgericht. And the first of them was actually the one from Germany's Bundespatentgericht, Federal Patent Court. And they said, and I think I have a translation here for you. They said, under German law, it is irrelevant on which actual development the invention is based, and whether named persons are to be regarded as inventors, so Davos, it is relevant whether the invention is based on the use of AI. That means an AI-generated invention is not excluded from patentability. The Federal Patent Court took a shortcut. It didn't make this long argument that I did, what is an invention, what is an inventor, and should it be excluded, and so on. They just take a shortcut and say, it's irrelevant how the invention was generated. Okay, fine. That means the primary question, is a computer-generated invention excluded from patentability, is answered to the negative, which is a positive thing, by the German Federal Patent Court. Yes, you can get a patent. Here again, and here is the translation. On the other hand, the exclusion of an AI from inventor designation does not lead to any limitation in the patentability of the corresponding invention. A very important statement, and in fact, indeed, a milestone. And why did the Bundespatentgericht, let me call it Bundespatentgericht, why did the Bundespatentgericht make these statements? Because, as you will see later on, we filed a number of requests that provoked the court, or gave the court the possibility to answer a couple of questions in a wide sense. In the US and around the world, there was only one request, one main request, which was we designate Davos as a matter. And then it was mainly easy for most of the courts to just say, hey, you have to name a human, go home. But we made a couple of other requests before the Bundespatentgericht, which you will see later on. And that opened up the way for the Bundespatentgericht to discuss the matter in a more wide framework. So, should computer-generated inventions be excluded from patentability? The EPO, in a preliminary opinion, made an allusion that for them excluding it would be in violation of Article 27 TRIPS, which asks for patents for all technical fields, including the technical field of computer-generated inventions. So actually, I think there is only one possible answer, and that is no, they should not be excluded. The patent system must be open for computer-generated inventions. And as I said, if you give any other answer, people will sit in line. Okay, let's move on. So if we have an invention made by a computer, and if we can get a patent for it, now who is the inventor? We know who is the inventor in the traditional sense. It's the computer. But who can be named? And is the traditional inventor required to be human? Well, I mean, my explanation made it more or less clear. The question here is patent law only made for man-made inventions? What is the purpose of the patent law? Now, the purpose of German copyright is to protect the interest of the author. Mozart composed this wonderful music, these operas, etc., and he didn't get a dime. People played his operas without paying him. Now, in the 19th century, ideas around copyright, for that reason, were generated, and the object of the German Copyright Act is to protect the interest of the authors. What is the object of patent law? Is the object to protect the interest of human inventors? I don't know. Let's see. When courts say you have to name a human, that doesn't necessarily mean that the object of patent law is to protect the interests of human inventors. That is quite a different question. Now, the object of patent law is actually defined in Article 7 of TRIPS. TRIPS is part of the World Trade Organization. I think Sweden and Germany are part of the World Trade Organization and are bound by TRIPS. And so are, I think, all member states of the European Patent Convention. So this definition by the legislator is binding. And it says, the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology, to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare and to a balance of rights and obligations. Has anybody discovered the inventor in this statement of the object? Of course not. So the object of the existence of patent laws has nothing to do with the role of the inventor. The inventor is on the big level of the objective of the existence of patent laws. The inventor is irrelevant. The producer that is named here in Article 7 is typically the applicant and not the inventor. The producer is, let's say, a company that is investing in R&D and devising new products. That is the producer. So the object, the aim, the target of patent law is technological progress. You may think that technology destroyed the world, is constantly destroying the world. It goes on. I will not contradict you, but that doesn't change the fact that those who passed patent laws did that to promote technology. If you say to save the world, we have to get rid of all technology, a bold statement. You can abolish patent law if you want. That's whatever you do. I don't care. But the legislators who passed patent laws did that to promote technology. And they did not do it to help the inventor. Because in many patent laws, the inventor is deprived, expropriated of any of his rights without any recompense in a second, in a millisecond after the creation. Okay, so do we need a human in the matter of inventing and patenting? Not necessarily, not from the point of view of the objective, which means once again that inventions generated by a computer can be patent protectable. And they cannot be excluded because the invention has not been created by a human. That is just not true. There is no statutory foundation for that. Well, to the contrary, the statutory foundation in Article 7 TRIPS makes it very clear that the aim is technology. And as the Bundespatentgericht said, never mind where it comes from. What we want to see is technology. So that was kind of first part, the material thing. Oh my God, time is running. Oh my God, yeah. Now the second part is, we know who the inventor is, it's the machine, but can we name the machine? So who must be named as inventor of a computer-generated invention before the Patent Office? Can we name the computer? And here is the Bundespatentgericht, quite interesting. That's a photo of me and my friend Marcus. We went to the Bundespatentgericht to defend the case, and our main request was DABUS. We named DABUS as inventor. And you probably all know it was denied, of course. Why was it denied? From the logic, which I go on here. Hang on, yeah, okay. We named the traditional inventor, which is the artificial intelligence. It was denied by the Bundespatentgericht. Here is a translation. Because only natural persons can be named as inventors and not machines. The reasons given are not so very much convincing, actually. The reasons given by the Bundespatentgericht. We will see something else in J8 of 80 from the European Patent Office. They said you need to name us a natural person because we have to present the name of the inventor, natural person, on the patent document. This is their moral right, and we have to take care of their moral rights. Now, the problem with this argument is the computer doesn't have moral rights. So why should we protect the moral rights of the computer, which doesn't have moral rights? So the reasoning is not really a success. Yeah, a better reasoning can be found somewhere else. Oh yeah, no, sorry. Where's the better reasoning? When does it come here? A little bit later. Yeah. We made a second request, our first auxiliary request, and it went, no one is named as inventor. So you don't accept the machine as inventor, but there is no human who qualifies as inventor. So please allow us not to name anybody. It was denied for the same very weak reasons, saying you need to name a human. But why? It wasn't very clear. It wasn't very clear. But it will be clear in a moment. So the traditional inventor, no one, they wouldn't do it. So we jump the inventor and go straight to the applicant. They wouldn't do it. Now the reason, a very, very, very good reason was given in J8 of 20 by the European Patent Office for basically the same question. At the European Patent Office, there was only the main request. Davos was named as inventor and they denied it. And they denied it for excellent reason, in my view. So J8 of 20 is a very good read. What did they say? They said, okay. They said, there is Article 81, you have to name the inventor, and there's Rule 19 and whatever, all circles around naming of the inventor, and it looks like they want you, the patent law wants you to name a natural person. But it's not so convincing if you have a computer as inventor, so what to do? But then they said the term inventor appears at several occasions in the European Patent Convention, and there is only one unitary meaning of the word inventor across the whole European Patent Convention. There isn't an inventor according to Article 60 and another inventor according to Article 81. No, it's one and the same inventor. And Article 60 reads, the right to European patent shall belong to the inventor. And the same in German, das Recht auf das Patent hat der Erfinder, paragraph 6 of the German Patent Act. So that makes it pretty clear, a couple of things, and that has been worked out very, very well in J8 out of 20. If the right to the patent belongs to the inventor, then the inventor must have a legal capability. He must be able to own the right to the patent, and the machine doesn't have legal capacity. It cannot own the right to the patent. In a more general sense, what any patent law does is define property. Before there were any patent laws, if your neighbor made a technical invention and you're doing, let's say, the same business, say, hey, excellent idea, I'll do it too. Your neighbor couldn't do anything because he didn't have any property. He didn't own any right to whatever, to his invention, to the patent or whatever. With the advent of patent law, property is defined. Property in what and to whom? Very often in the legal history of mankind, you will find the definition of property for whatever, for houses, for cars, for water, for the river, perhaps, for the woods. Now, the sky here in Frankfurt today is very gray. It's raining. Who owns the clouds? As of today, nobody. As of today. But people are talking about the water in the clouds, which they would like to draw to the soil. Who knows? Maybe one day we'll have laws that regulate who owns or who can use the water in the clouds. Today, we can't. The woods in Germany belonged, in the past, 2,000 years ago, belonged to everybody or nobody. Today, they belong to the duke, the earl, or whatever. Same in England, the pasture for the sheep. Traditionally, they belonged to nobody. Everybody could make their sheep graze on whatever land they wanted, but at a certain point in time, 12th century, I think, the land was subdivided into individual pastures with walls around them, which belonged to individual people. Now, so any such property defining law defines property in something and gives it to somebody. And that is what this law needs to do. Define what you can own and who can own it. Now, the patent law says what you can own, rights to an invention, a technical teaching. And who can own it? Well, the decision by the legislator is clear: the inventor. Not the state, not the church, not my grandmother, the inventor. And not the applicant. That is a very important legislative decision. Let me see whether I have it here. Yeah, back in 1877, the first patent law that covered the whole of Germany, the right was not given to the inventor, but to the applicant. The person who first filed an application for the invention in accordance with this act shall be entitled to the grant of the patent. So back then it was the applicant, but in 1934, following a revision of the Paris Convention, the system was changed from it belongs to the applicant to it belongs to the inventor. Now we have a vesting of the right to the invention in the inventor. And that was very, very well worked out by J8 out of 20. We also have the creation of the right to the patent. If there is an invention, originally there is no right in this invention, even with the existence of patent law. What you have to do is you have to file a patent application with the patent office, and you have to name an inventor with legal capacity, which is a natural person. And if you do that, the right to the patent comes into existence. And until you do that, the right does not exist. It hasn't come into existence. And that is the point that was very well worked out by J820. If you name a machine as inventor, the right does not come into existence. It does simply not exist, and there is nothing that patent office can talk about. There is no right to the invention, so there's no point in pursuing, prosecuting, examining, searching, whatever the patent application. And of course, the designation of inventor is defective then as well. Because it now becomes clear why the designation of inventors is asking you to name a natural person, because otherwise there won't be a right to the patent. And it is also clear that we need a natural person, at least in Germany it's clear that we need a natural person with legal capacity and not a legal person. Because back in 1934, they changed from the applicant to the inventor to vest that right. And it was clear that they don't accept anymore inventions made by a company. No, all inventions are made by an individual natural person. If you can call that a legal definition, but that's the only thing that is accepted. By law, that's what patent law is asking for. Okay, so I may be a little bit quicker in what follows because the major statements have been made, but I have a few slides, but let me be quicker. Yeah, so we have the two rows, inventor and applicant, and we have computers and humans. Applicant meaning the owner of the right. And now the computer can be the inventor, the actual deviser, but the computer cannot own the right. He can't be the applicant. The human can be the applicant, but in this particular case, the case we're talking about, the human is the inventor. So the two roles, inventor and applicant, fall apart. Traditionally, they were meant to be identical. You are the inventor, therefore you are the owner of the rights, which I called here the applicant. Identity, that's why you are the owner of the right because you are the inventor. Because we have identity in your role as inventor, therefore we give you the role of owner of the right. And that doesn't work anymore now. And how do we get right from the actual device of the computer to the human? Can the computer sign an assignment or whatever? Now, the good thing is very, very, very nice, actually, that the European Patent Office said, if you name that you can't transfer the right from the computer to the human as applicant, or even a legal personality as applicant, because the right doesn't exist. You name the computer as inventor. That means the right to the patent doesn't exist. And therefore you can't transfer it. And there are other reasons why you can't transfer it, but at least this reason is very clear. So what you need to do is you need to name some human as inventor. That human is not the actual deviser, so it can only be a deemed inventor. In my words, the European Patent Office didn't say that, but that's what actually it is. Okay, let me summarize this really nice decision, J8 out of 20. What did they say? So number one, an invention generated by an artificial intelligence may be patentable. Very nice. Actually, a very, very important statement. Number two, the origin of the right to the European patent is defined in Article 60 EPC. Article 60 governs the origin of the right to the patent and the vesting of this right to the inventor. The designated inventor must therefore be a natural person with legal capacity. If an AI is designated as inventor, the right to the patent is not created. A right that does not exist cannot be transferred from the inventor to the applicant. The reasons given in J8 out of 20 to the same questions are, in my view, a lot better than those given by the Bundespatentgericht. I really think that J8 out of 20 is an excellent decision. So as I said, I would say we need a deemed inventor, and we can be inspired by UK copyright law. In the case of a literary work which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. That is British copyright law. Germany refused to take that over in German copyright law, which is okay, makes sense, but it could inspire us to a new definition of inventor for a computer-generated invention in patent law. The EPC doesn't have a statutory definition of inventor, nor does Germany, so there is room for case law further developing the definition of inventor and developing a little bit, a small piece of new law. So who should be named as inventor? The traditional inventor, the AI? No. No one? No, we need a deemed inventor. Who can be the deemed inventor? There were suggestions to make the applicant the deemed inventor. So Siemens. That doesn't work because Siemens is not a natural person. The owner of the AI will typically be a company, so that doesn't work either. So the deemed inventor needs to be a natural person. So this is a suggestion from me. It's neither law nor case law. I would think it reasonable to say, in the case of a computer-generated invention, the natural person who contributed to the generation of the invention by the computer shall be taken to be the inventor. It is a fiction, a legal fiction. That human person was not the inventor, the machine was. But we should deem that person the inventor because we need a natural person. So what natural persons might qualify as deemed inventor? We can differentiate three temporal regimes: the creation of the AI, the use of the AI, and the reception of the output. Now, the creation of the AI, we have the programmer or the person who trained it, or even more persons. The problem here is, if I'm Autodesk and I sell my software to a client, and the client makes a design, then my employees would be the inventors of the design made by my client. I don't think that anybody would want to have that, actually. Now, the receiver of the output, that was brought forward a couple of times. It does not convince me. But because what does the receiver of the output do? Does he say, hey, this is an invention? But it's been an invention already before he said that, because it's a technical teaching. So it doesn't really help. And I picked this to file it for a patent. Does that make something an invention that hadn't been an invention before? No, I don't think so. So I think we need to look for the deemed inventor in the realm of the use of the AI. The person who posed the problem, or maybe the person who controlled the AI, who actually did the manipulation. My personal preference is on the person who posed the problem, because otherwise you may have an employee who knows how to handle this software program, maybe by Autodesk. He knows how to make these designs. So that person would then always be the inventor, and in Germany would always receive the inventor remuneration. I think that would create some sort of imbalance, perhaps. While the person who said, hey, I have this problem, and I think your machine might be of help, can you give it a try? I think that is, for me, a fair candidate for the deemed inventor. Okay, what else did we do? I'm hurrying, I know time is running. I'm hurrying. We filed a second auxiliary request, naming Stephen L. Thaler as inventor and adding a paragraph in the description saying, but actually the invention was made by Davos. This was refused by the Bundespatentgericht because they said it is added matter. Now we are now in appeal at the Federal Court of Justice, so the kind of Supreme Court in Germany, and we will argue this point because we don't think it is added matter. And actually in J8 out of 20, you will find a passage saying the best, if you want to say something about Davos, do it in the description. So that is actually the best place to do it, but it was refused by the Bundespatentgericht. Let's see what the result from the Bundesgerichtshof, the Federal Court of Justice, will be. What the Bundespatentgericht did let go by is the designation of inventor, saying Stephen L. Thaler, who made the arrangements for the artificial intelligence named Davos to generate the invention. The president of the German Patent Office argued against it with reasons which are not so important for us here today, but these reasons did not convince us, and they did not convince the Bundespatentgericht. So this was accepted, and for the first time we had a positive decision. Yes, you can have a patent in case you draft the designation of inventors in a certain manner, which was kind of a landmark decision in my view. At least I was extremely happy when I went home. So putting all this flow diagram together will lead to something like this, which you might think it resembles this game. But if you block all these things, which I think are not convincing, and if you give it a closer look, you will find one single course of argument that will lead you naturally to the person who posed the answer to all these questions. Yes, they can generate inventions. Yes, you can get a patent. No, you cannot name Davos. Yes, you have to name a human being. Which one? The person who posed the problem, probably. Okay, I think I can leave you now. I think the content of this slide is pretty clear, what it all means. Computers can devise inventions and so on and so on. I think I mentioned that. What is the international situation? First row reads, can a computer devise an invention? Second row reads, can you get a patent? Most offices now say yes, yes. And last row, who has to be named as inventor? It must be a human, except WIPO and South Africa, but I don't think we have to take that too seriously. I think the international consensus is you have to name a natural person. And yes, we're done.